All right, to our top focus this Monday evening, as the opposition continues to question the elevation of Justice Nazir to the post of Governor of Andhra Pradesh, the politics over it continues. Republic spoke exclusively to the former Law Secretary P.K. Malhotra and former ASG Senior Advocate Siddharth Luthra on Justice Nazir's appointment as the Governor of Andhra Pradesh. So while the TMC Congress as well as the Aam Aadmi Party continue to question the appointment of Justice Nazir as the Governor of Andhra Pradesh, Republic speaks to Senior Advocate Siddharth Luthra on Justice Nazir's appointment. Let's listen into those exclusive interactions we've had with Siddharth Luthra, the Senior Advocate, as well as the former Law Secretary P.K. Malhotra.
Under the Constitution, or there is no law which prohibit appointment of a retired Supreme Court or High Court judge as governor. And there are precedents in the past. The Supreme Court judges, even the Chief Justice, former Chief Justice, have been appointed as governor. But the question remains, I think important question that arises is, if a judge is given appointment on this type of important constitutional position, probably there may be people who feel that probably there is some kind of quid pro quo. It may be totally misplaced, but the fact remains that kind of message should not go to the public if we want to keep the image of the judiciary in the mind of the people, because people respect judiciary like anything. In case of any wrong done to them, they approach the judiciary and they expect justice from the judiciary. So I personally feel, because there is no legal bar, if government has made appointment in the past, and even with regard to Justice Nazir, there is no illegality on it. But I think looking at the statement made by even Mr. Arun Jaitley on the floor of the House, that judges, sometime in case this type of appointment are made, probably to the future persons, judges who are retiring, their judgments may be affected or influenced by this kind of appointment. If we are sending that kind of a message, probably that will be wrong. So I think the solution available is, instead of immediately making an appointment, if there is some cooling off period or some gap is there in the retirement of the judge and his appointment on some other important position. I'm not talking of appointments where by law itself it is said that the retired judge will be appointed, like appointments in the tribunal, or for that matter appointment of Lokpal. If there the qualification presumes itself is like that, there is no issue. But if you are making appointment on a post where judges are not necessarily the only appointee, there can be other eligible persons also, probably there should be some time gap in their retirement and in their appointment on that kind of important constitutional positions.
We have to have consistency. Either we do away with all post-retirement appointments of judges, that's one way to look at it. Alternatively, and then that means all the commissions, all the tribunals then are not, which are by law required to be headed by persons who have or have been judges of the High Court or Supreme Court. Those provisions will have to be modified to ensure that there is nothing post-retirement. If it has to be done, it has to be done within the tenure, whether the age is 65, 70 or whatever. That's the first part. But once that system exists, and the issue of post-retirement jobs for judges by way of various statutes and through commissions and tribunals is something which we as a society have accepted, then I don't think it's fair to say that there should be a cooling off period, because what difference does it make once the avenue and the legality of the appointment is permissible by law? What Mr. Jaitley said had a lot of merit, as a lot of things he said, but the fact is, irrespective of which government is in power, any dispensation that is in power will have to look at reform. Even the current administration, which sought to reform the tribunals and reduce the number of tribunals and commissions, has not done away with it. They've still continued. And even in this tenure, there are people who are getting appointments post-retirement. It's not that it's not happened. for example, Chief Justice Bobde has declined to accept any appointment. That's a matter of personal choice. So one is the legality of the opportunity or the jobs. I don't think there's a question on the legality. On the cooling off period, I don't think there is any such norm which is rational or legitimate. The third issue is it is a matter of choice of the individual concerned. Do you want to accept it or don't you want to accept it? And that's a matter of personal choice. So these are the three elements we have to judge it. And it's unfortunate that every dispensation that comes blames another dispensation. Nobody wants to look at the issue, that is, should there or should there not be post-retirement jobs for judges or bureaucrats, because we have to see this across the board. It's not, today we're talking about judges, what about bureaucrats who get appointed to commission? What Mr. Jaitley said had a lot of merit, as a lot of things he said, but the fact is, irrespective of which government is in power, any dispensation that is in power will have to look at reform. Even the current administration, which sought to reform the tribunals and reduce the number of tribunals and commissions, has not done away with it. They've still continued. And even in this tenure, there are people who are getting appointments post-retirement. It's not that it's not happened. For example, Chief Justice Bobde has declined to accept any appointment. That's a matter of personal choice. So one is the legality of the opportunity or the jobs. I don't think there's a question on the legality. On the cooling off period, I don't think there is any such